Welcome and thank you for joining us today on A Lawyer and a Mediator Walk into a Bar. We'd like to acknowledge the traditional custodians of the land from which we broadcast today and acknowledge their elders, past, present, and emerging. This show is not about legal advice. It's really just about our experiences going through the process in the family law courts, what can work, what doesn't work, what's for you to consider to try. And it's just about the process, giving you some familiarity with it, and hope that gives you a little bit of a help.
You're listening to a Mel and Kim Productions podcast. What happens when a lawyer and a family mediator step into a bar? Join us to find out. Diane and Paula have real conversations about the family law process in Australia. Whether you're a part of the family law system or about to engage in the process, find out what the realities versus perceptions are. Diane and Paula don't hold back on their individual perspectives and experiences.
Welcome back to A Lawyer and a Mediator Walk into a Bar. Thank you for joining us again this week. My name is Diane Loveday from Bayside Mediation, and my colleague is
Paula Applehans from Betts Law Company.
And following on from last week, where we talked in depth about child-inclusive process and child-inclusive mediation, so specifically around the mediation process, I thought today it would be really good to look at how
What's the other side of that coin?
Yeah, how children are included when you actually do go into litigation and are using the court system, especially in light of the new legislation, because, you know, as a mediator, I'm really interested to see.
I think we're all a little anxious to see how it's going to roll out.
Yeah.
There was lots of anxiety, I know, so there's a process called an independent children's lawyer, and their only job in this entire legal process is what's in the best interest of the child. So that's their job. Mm-hmm. Sometimes that's wrangling the parents to reduce some of the conflict. So it's not even that they're the voice of the child. It's what's in the best interest in this process.
Right.
So that seemed to be, we can bring an independent children's lawyer on, I think, and we probably should, because it is a very important part. Now, when I first, in 2021, there was a merger of the courts.
Yeah.
And independent children's lawyers may not always be assigned. They like to assign them more to high conflict cases or other substance abuse, other issues that are involved with that. But for those years that I've been doing this, and the independent children's lawyer, I'm going to call them ICLs because it's jargon, easy, I know, but independent children's lawyers gets a little verbose to keep repeating it. Most of them never met the child or the children of the family. And I had one situation where the children were, like, I want to say between 8, one was 8, one was 10 at the time we started. Keep that in mind, at the time we started.
Yep.
I think that's going to be the phrase throughout most of these issues when it comes to children. At the time they started. Mm-hmm. At the time they started the process, they were 8 and 10 years old. By the time they finished, they were 11 and 13.
Yeah.
So, and this entire time, for the 3 years we were in litigation, we were in industrial strength litigation. The other side was pushing every avenue they could. The children had spent a lot of time with the father. They both lived at home, with mom and dad until the breakup. But it was the dad who took him out, motorcycling, got him out into sports, took him out on the weekends, took him to the river on the weekends. I mean, there's all these episodes where they had all these fond memories with dad. Now, unfortunately, mom had been an alcoholic. But she was in recovery, and everybody was promoting the recovery. Don't get me wrong, because that's the one thing I stand firm on. We're not going to, if somebody's in recovery, that's what it is, and that's where we take them at. Yeah. We're not going to go back and browbeat. But unfortunately, there were things that had happened during the time when the children were younger, when she had been drinking, that the memories started coming out. Oh, okay. And they started coming out to the dad because that's where they felt they were safe to talk about. Mm-hmm. They felt that the mother would get angry. She had shown episodes of anger, things where, maybe... Now, again, back in the day when somebody took a wooden spoon to you, that wasn't a big deal. That was just Thursday. I mean, So I mean, all these things started coming out with the children. So again, at this point, everybody's in family therapy, individual therapy for the children. All the mechanisms that are supposed to be going on are going on. But at no time did the independent children's lawyer, the ICL, have a conversation with the kids.
In 3 years.
Yeah. Now, part of that is because there was no requirement to.
Right.
And again, part of it wasn't so much about the child as it was about, is the child having a fair go in the process? So again, it's an avenue of the process, but it wasn't really a fulfilling aspect for the children. So, but May 6th, lots of changes came about in the family law court, and now there is a requirement for the independent children's lawyer. So again, one of the big changes in May 6th was that the independent children's lawyer are now required to talk to the children. Now, that has its own, I don't want to say perils. I have worked with some very strong ICLs, and it was because of one of them that we were able to get a parenting order together. Right. She was that strong, that firm, very precise, pointed to the children's therapy reports, pointed to the family impact report. I mean, she was so on it. I was actually very grateful for her assistance to do this. But one of the big things I hear about is cost and time.
Yeah.
You know, they're assigned these cases from the federal court. They might be a little inundated. They're not getting, as far as I know at the time, they weren't getting extra fees to go meet the child.
Okay.
So, I mean, fair enough. You know, nobody works for free in this deal.
No.
But that now, and that's only been, again, guys, this is what, September.
Yes.
This has only been since May.
Yeah.
So I do think we need to bring somebody on board. But the entire process from the get-go, from the minute you file, the children are not supposed to be involved. They're not supposed to know about the process. You know, the children, that they go back and forth between the parents and like, oh, yeah, dad says that the court says, you know, or they'll just say, court says we can't do that. Yeah, well, that's involving them in the process.
But isn't there a thing called the paramountcy principle in law?
Well, yeah. Again, we're trying to stay away from legal terms.
I know, but that one I like.
That one,
I like, because my understanding of it is that children are supposed to then be the paramount consideration in any of these.
Well, now it's the best interest of the child. Right. It's been a phrase, gosh, way back when I was in law school. What's in the best interest? But how do you define that? What does it look like? And it's going to be different for every situation in many ways. So do you want a definition that's, very precise, or do you want something that's open enough to deal with all the different situations that come across? Mm-hmm. And like you said, the best interest. One parent says this is in the best interest. It's in the best interest of the child to not drive an hour each way for changeovers. Well, you're talking to an LA girl, so driving an hour and a half just means I only went 3 miles. So,
but I've had other parents who talk about the how precious that time is, because you're one-on-one with the child in the car. You can have conversations.
Or you're in there singing.
Or you can make that time to talk to the other parent. Let's ring daddy now or mummy now, because
you're on your way home and you can tell them what's going on and how much fun, or what did you do, what did you eat.
Opportunities in that time if you choose to utilize. Yeah.
Well, I mean, I've got one parent that was teaching Spanish, singing songs in Spanish to the child, at 3 years old. Yeah, I was like, ooh. Well, that's a good. I never thought about that. But then you think about again, way back when, the car rides. I remember as a kid on vacation, my dad would give us math problems.
So we lived in the country, so it was I Spy.
So there you go. It was here's a math problems, and the train station left at this, and I'm talking we were like 8, 9, and 10. I mean, so they were simplified, but that was my dad. That was his idea of fun, or radio shows with the shadow, the shadow knows. Yeah, that maybe goes too far. It was old then, but the whole point is that one parent says 1 hour is too long, the other parent says, oh, but we're having a great time. Mm. Yeah. But they come back to me cranky. Okay.
But then I just want to touch on that, because that was in my experience with the child inclusive process. I remember listening to a psychologist explain, because that exact conversation was happening, mm-hmm. and the psychologist said, you've got to remember that changeover for a child is a little like grief, because they're leaving somebody they love. and knowing they're not going to see them for an extended period of time. And depending on how young the child is,
Right. It could be forever.
yeah,
For all they know.
Yeah,
It's like-
exactly. They
like a
have no
dog. It's
concept
for
of
you
time.
leaving
Yeah.
forever.
So of course it's normal for them to be distressed.
Yeah.
Or naughty or irritable or, so one of the things I try and get parents to focus on is give kids a time to adjust.
And that's the whole thing. It's that adjustment period, isn't
Yeah.
it? I mean,
Yeah.
it's going to happen. It's going to have to happen, but how do you do it?
Yeah.
So, but then you got one side always screaming, best interest of the child is that, I should only be 15 minutes away, or I should only, so everybody's got their own definitions. And that's fine because every situation is different. And you do try to understand that there's going to be differences of opinion. But at the same time, you still have to get to a structure. And if somebody's just going to be obstructive and no, that's not going to happen. You must be my way or the highway. So this is where we get involved in when it comes to filing in court. Because it doesn't get decided right away. We've talked about where, things can take some time. So unless there's an urgent need, such as you're worried about the child being relocated, the child going out of country, the child being, just taken, or if there's family violence involved, or, you've got a text message on the co-parenting app that one of the parents says, I'm gonna hurt the child because, you get them more time now, and I just want to make it, whatever it is, at that point. So once you get into the process, the children are not supposed to know. There are actual provisions that go in most orders. Non-disparagement, that's a big one. The other is not involved in the process, and do not talk to anybody else about the process. So I had one situation where, the couple had separated. They had some property involved, no children though. But in the meantime, the other side is talking with, but their relationships. I have had relationships that I have broken up with a person and my parents are still talking to them. They're still talking to the family. They're still talking to the brother or sister, aunt, uncle. I mean, things occur. So I think where we were going with that was that the idea is that you talk to somebody in your family to gain perspective, talk to somebody in your family, to de-stress, things like that. And they came back and was like, oh, you talked to, my client's sister. Uh-huh. And you told them about the process. Well, they're a witness. We're going to take you back to court for controversy. We're going to take you back to court because you told somebody else about the process and you shouldn't have. Little Timmy came home and said, one parent hates the other one, and I hate that parent now too. Or the court says I can only talk to so-and-so. I can't talk to this other person or grandparent or, I have seen orders that lasted 10 pages, and these are interim orders. These are just what's going to happen in between time. And they were, 10 pages long. So are they really doing something in the best interest of the child, or are they just rocking up revenue? I don't want to see it. I don't want. But at the same time, it should, I don't want to say it's not always simple, because it isn't. But in some ways, if you take out all the other bits, that are, may be valid, may be important, but it really just comes down to how much time can each person spend? How much can each person afford to spend? And when I say afford, I mean somebody's working, fly in, fly out. They're only in every 2 weeks or something. So, you can't ding that person because they still want to be a part of the child's life. And like you said, what if the child, that's their person? Yeah. Isn't it that Grey's Anatomy? It's like, you're my person. Yeah. So kids have their people. Yeah, pets have their people. Yeah. Everybody has their people.
Well, that's it. But with kids, your person will shift as you get older. Yeah,
they do. They're supposed to.
Tell me about the family reports, because this is I've seen a number of clients go down this path.
Well, once you get into the court, one of the first things the other side, or either side, usually agree to that there should be some sort of family report, child impact report. There's all these, There's a couple levels of reports you can ask for. You might need them. Part of it, again, has the child been coached? Has the child, the child's coming to one parent saying all these things, nasty things, that only adults would say, and the kid's 5 years old, 6 years old. So, you want that family report. You want that child impact report. But it goes again to a third person. These things are not cheap.
No.
I think the average right now that I've had used, are between 8,000 and 10,000 per report.
I've heard one up to 25.
Well, if the parents are willing to pay that's out of my league.
Yeah,
But,
it's a lot
but
of
even
money.
10,000. Now you share the cost unless there are financial issues, and again, that's something you have to fight about. When it comes to the hearings, because you're just trying to get to the next phase. Well, if you don't have all the information, you do the intake. You as a single entity do the intake. You get to see both sides already. Here, we're just adversarial from the get-go. From the minute you file. And at that point, you need a third person to say, where are we at on these things? Everybody pays $5,000 a piece. You try to get in. Sometimes it can take at least a month, at least, even for a private report. Right. Now, if you get an order through the family court for a family report, and they decide, or they farm out that process to somebody else, that can take even longer. So most people are encouraged, if they can, to do the private report, because hopefully you'll get in before 30 to 60 days.
Right.
30 to 45 is not unusual. Again, this is not fast. This is not rapid. Decisions are not going to be made. So even once you get the family report and they say, okay, what's the date you're going to have it by? Here's the date everybody has to show up. So mom and dad have to show up, or the parents have to show up. The child has to show up. The person who's doing the family report will get maybe 2 hours with each parent, maybe an hour with the child, and then another hour with each parent and the child, all in one day. So it's a big
day. That's a big day.
It's a big day for everybody,
Yeah.
and again, that anxiety, the stress. The child is like, "What the heck is going on?
Mm-hmm.
Why do I have to tell?" Especially when they start getting older, it's like, "Why am I talking to this person?"
Yeah, when I've spoken to this person and this person and this. Now I have to do this again.
So the issue I had, the challenge we had with the child that went on the case that went on for 3 years, we ended up with probably 3 different family therapists, 2 children's therapists, just for the children, because mom didn't like the first one. So that one actually waved off and said, mom's been very intrusive. I've had to have a think about it. I mean, she's wonderful woman. The children had identified with her, were actually getting to the point where they were talking to her, felt comfortable, and she was not just rolling over and letting the kids tell them whatever. She was very good, very structured. But mom had enough. She thought she was being bad-mouthed in therapy. And so that one. But I mean, in 3 years, to have 4 or 5 different people, by the time we got to the last year, the kids were like, that's it, we're done. Yeah. We're not talking to anybody else. Yeah. It's like, well, the court says, I don't care. Yeah. Because kids don't care. At that point, they're
put me in jail. I don't care.
Yeah. I mean, one therapist, they had to drive they had to drive an hour from outside of Melbourne back into Melbourne to do this. And it was probably once every 2 weeks at one point. So you talk about maybe an hour's time. But at the same time, they're going to see this person. It's a struggle. But they're spending time with mom. They're spending time with dad at the therapy session, which is the good part. Good, bad, or ugly. At least they're attempting to do some things. But again, 30 to 60 days out, even if you're paying for it, then you have to go back to court with the report and try to identify what are the real issues, what are the real challenges, what are the things that are in agreement. I start with, what are we agreeing on? Not what's different. My first thing is, well, you know what? That's the funny part. And I think that's why other solicitors get mad at me, because I'm like, first thing is like, okay, it looks like we agree on this. And they're like, well, we didn't say we agreed. It's like, okay, it's in the family report. Let's have that discussion then if you don't agree. But I'm not understanding where the challenge is here for you, because it applies to both parties. So, but I mean, these are really, some of these recommendations are just almost common horse sense. Yeah. And that's all, and that's what it's coming down to. And then we can always talk about the expert, so they're a single expert witness. You don't get to pick your own. Both parties, I think the process now is literally, instead of having the experts fight it out in the witness box at a trial, the court now says the central practice guidelines, the rules are like, one side picks 3, the other side picks one of those 3. That's your single expert.
Wow.
So, yeah, it's not like you can say, oh, well, I want this. And you do. I mean, solicitors duke it out. I've got 3 that I enjoy. I think they're fair. Not that they come up with anything better or worse. Their price point is pretty decent and reasonable. They do get the turnaround. When they say they're going to do something, I have found that they do it.
That's a big part of it, isn't it? Getting
yeah. And one woman recently, she's like, I'm sorry, I've had the flu for like 2 weeks. Yeah, it's like, yeah, but we've got the next mention hearing in a week.
Yeah.
So
I need it, please. I need it. Yeah.
I really appreciate that you're sick. I do. We do have a court date, and she's like, I know, I'll do what I can to get it to you.
And that's the other. Sorry, I'm digressing a little bit, but I've had a couple of clients recently where I've been trying to set up appointments for the child inclusive process. So I've got to manage my diary, the therapist's diary, mum's diary, and dad's diary to get everybody in the one space.
Oh, and if the kids are in activities, you got to manage their diary.
Well, yes. I generally try to do it during school time.
Right.
But you know, I'll get people saying, "Oh, well, look, I can't come. I've got a meeting," or "I can't come. I've got work commitments. I can't go." And I write back, "Well, you know, if you're in court."
They don't care.
They don't care. There is absolutely no negotiation. Yeah, you have to attend, otherwise you're in contempt. So
I find I say that a lot. Is like, they don't care.
They don't care. Yeah,
I care. You care.
yeah.
They don't care.
They don't care. No.
Here's the date, you know, and this is what it is.
And
Now, if you're in the hospital, if you're out of country for, family reasons, death in the, these are things obviously that are, we're not talking about these things.
No, we're talking about, I've got an important meeting. I don't care.
It's like, well, so do I. I've rescheduled.
Yeah.
And that's how the court, could you reschedule? Anyway, but it becomes a thing.
Yeah.
So, and especially with trying to get everybody in on the day.
Yes.
Sometimes, and because that's how most therapists, most of the family report writers, that's how they manage their time.
Yeah.
So they're not going to be picking up pieces 2 hours here, 2 hours there. It's a day commitment. They're focused. The family's hopefully focused. Then they've got 2 weeks to write the report. Some can take another 30 days to write the report. So you have to be realistic when you're going into the directions hearing that says, when can this be done?
Yeah.
The court wants to know, when can this be done? Don't give me a maybe. Don't give me. So when both solicitors go in, we have to have dates and times committed to before we go back to the court and say, okay, the proposed order is that we do this. They'll have it. We've talked to the report writer. They say they can absolutely have this date free. We've secured the date, blah, blah, blah. But then all that stuff still has to get done.
Right.
What if the child's sick that day? Oh, that happens. Yeah. So these are all these things that happen. If you're lucky, you might get back to the court in 2 months because that gives them 6 weeks, hopefully, to get things done. Gives you hopefully a week or two to read the stuff. And then you have a time frame for which to challenge or question things in the report. But even then, it's just clarification. It's not even a challenge. We need clarification, please. You said this in your report. Can you please identify what that meant? So, and you're only given 14 days to do that. So, but again, all this has to be done before you go back to the court. So it's not, and even then, it's just a directions hearing as to, okay, this has to be filed, this has to be filed. We do all the procedural stuff. And then we get an interim defendant hearing. So again, and I laugh about it because sometimes it's a maniacal laugh as to how long. Because but my child, they changed the parenting plans that we had agreed to in mediation. Mm-hmm. All of a sudden, I only have 1 day a week now instead of 3. Yeah. I only get 1 weekend, maybe 2 weekends out of the month. It's whatever the mom decides because, she's holding the kid if I don't agree. It's not even a discussion with the other parent. It's the other parent is deciding. Yeah. And unilateral decisions.
Concept of ownership.
Well, yeah, poor kid. The idea of somebody saying, I own this kid. Oh,
it's my child.
Yeah, my child, my choice, my decisions. And when you're young, you go through that. You do.
Look, I point out you can actually have your children taken off you by the state. Let's be really clear.
So so once you file, you get to the point where you get to the first directions here, the first return, you're deciding that you need some sort of family report, child impact report. Is it going to be a private report? Is it going to be something through the court itself? And then they have to decide what's the, best, when can they schedule? I mean, poor registrars. I see them sometimes spend 5-10 minutes trying to figure out what the next schedule is to get somebody in. Or okay, we'll send this off to family report writers, and we'll let you know as soon as we get a date, and we'll put that in the order for you when we get it. So again, everything's so up in the air. If you can afford to do it privately, you can at least have a smidgen of control of how it works. It's still 30 to 60 days down the road, depending on the scheduling, depending on if the kid gets sick, you get sick, something happens and you don't make that appointment. How fast can you redo that appointment? And then, again, just to get to an interim defended hearing. So hopefully, if all goes well, you might get that interim defended hearing within 6 months. But during this whole time, whatever that parent in charge or making all the unilateral decisions, hopefully you will have come up with at least some sort of spend time arrangement. It may be the one that, unfortunately, a lot of times the court just goes to, well, what's happening now? Okay, stamp it. We'll just keep it that way for now. Even though that was a major change from a month ago or 2 months ago.
It's really disappointing if you've got a parenting plan that says blah, and they've agreed on it and signed off on it.
Doesn't mean they're enforceable, right? We've talked about that.
But they're supposed to be taken into consideration. At what point are they then taken into consideration?
Interim defended hearing would be the first shot.
First shot? So 6 months.
Now, I did have one less than, oh my gosh, it happened almost like rapid fire. We were really surprised. So within 30 days, we got an interim defended hearing from the next, but it's still 2 directions hearings before we get to the interim defended. And that was really because we were able to get the family report.
Right.
And get the report itself.
Because they went private.
Yeah, they went private. So there we go. 6 months.
I'm exhausted.
Tell me about it. So yeah, that's why in some ways when we do this show, I really want people to think about it. Now, at the same time, there are going to be requirements that, if the other side is not listening to the parenting plan, the other side is picking up and taking off when willy-nilly and not making any arrangements, basically isolating the other parent. Court's the only way you can get anything done.
Unfortunately,
Yeah. So there are times where it's like, okay, rubber meets the road, time to go.
And again, from the mediation side of the conversation, the frustration that the assumption is, we'll mediate once. If it doesn't work, then we'll go to litigation.
Well, sometimes the court will require you to go back to court-sponsored mediation with a registrar, somebody who knows the family law court. Sometimes
we've had people ordered back through us.
Yeah,
occasionally. Yep. Yeah, it happens from time to time.
But if the contentions are so great and the conflict is so great between it, is it really an option? Some people say yes because it's court ordered. You have to go do it.
Yeah, have to go do it. Yeah, and look, I sent one back to court because
they just
well, there was legal issues that I couldn't resolve. So I
mine have been the personalities. The other side is just obstinate. First thing is, I've had them walk in to say, I'm not agreeing to anything other than what I've already agreed. What I've already presented. That's it. It's like, well, that's not a good faith effort either. No. But they run with it and they do it, and it's like, okay, well, then 20 minutes later we're done. But yeah, we've had to pay for the mediator for a full day at $4,400.
And the personality thing for me, when we talk about personalities being, if it's a difficult personality, then litigation is probably your only real option. I struggle with that because, again, if I had $1 for every difficult personality that walks through my front door, my work door, I'd be both. I'd be good. I'd be,
we'd be
I'd be
retired.
holidaying in the south of France. Because it is a proliferation in our society at the moment of people with a sense of entitlement and a sense of ownership over either be their finances or their children or whatever. Yeah. So it's there. It's a lot. So the skill of the mediator is to break that down and to get to the real issues and to work through the process and to give the other parents strategies to deal, because often they get to us, they're exhausted. They've been in they've been
in a fight. They're in a battle
for a long time.
Mm-hmm.
So then, so what can you do to protect yourself, protect your children, and then you're going to have to parent with this person, whether it's now or after litigation.
Most of them, it's another 15 years minimum.
Yeah,
but
exactly.
Really, it's for life. Hate to say it, it's for life.
Well, do you want to be able to, both be at the wedding? Do you want to both be able to attend graduation? Do you want to be there? Do you have to want to compete about who picks up the first grandchild? Of course not. You want to be able to do that together. So I think there's, And I think that's a big difference. For me, difficult personality types just part of the course. You know, and my job is to try and help them become more focused on children and an outcome.
Well, I find those conversations a lot, you know, and when they get to me as well. But at the same time, once they get to me, people are entrenched.
Yeah, and that's
People
the
are-
difference, yeah.
Yeah,
And they've been supported by somebody who's only heard their side of the story.
exactly.
And
that's
that's-
all.
that's
Or,
a
you know, they
huge
shop
difference.
around until they find that person anyway.
Yeah.
I just tell people again, adversarial.
Yeah.
Adversarial.
But-
We are taking swords and fighting, and as much as you want to, as a professional solicitor, you don't want to engage that because, again, you as a professional know that gets nowhere.
Yeah.
But there are solicitors that's exactly what somebody wanted to find.
Mm-hmm.
That's exactly what they're doing.
Yep.
You know,
Oh, look, there
and
are.
that's where we're at. And okay, how do we move? How do we just keep moving? Just keep moving.
Yeah. I suppose the point I'm trying to make from my perspective is if you think you are in a relationship where the other party is too adversarial or too difficult to come to mediation, then it's really important to do your homework because often they're not. Often you're just in the eye of the storm.
But there's
Yeah.
so much information. So
Yeah.
listen to the podcast, get your options, get some ideas.
Talk to people. Come and talk to a mediator.
Oh, okay. Talk to people. So,
Yeah.
don't talk to the school group
No.
of parents who've gone through this
No.
and they give you their
No.
war stories.
No, talk to
because
somebody who
it's-
actually works in the field.
Yeah.
And if you're talking to a lawyer and their first thing is, okay, now we can litigate this, walk away. I can say that.
You can say that. I would suggest when you have that conversation, make sure you understand
What litigation engages.
what that really entails. Make
Yeah.
sure that person explains it to you.
Yeah.
And it explains the timelines. That's what
Cost.
people get.
And timelines and possible outcomes.
Yeah. Make sure
Because it's
that's
not
what
just
you get.
your view that will be taken into account.
Well, once you litigate, it's not your view at all anymore.
Exactly. Exactly.
Thanks again for joining
Thank
us.
you for listening again. It's been it's a pleasure as always, and we'll catch you next time.
Thank you.